Hi, folks. This is Curt and welcome to another edition of Fire Law Roundup, this time for October 3rd of 2022. And let me just click this box right here so we don't have some feedback, and we're ready to go. Brad is in Europe, somewhere in Europe. I know he was in France and Germany, France and Switzerland last week, and I'm not sure where he is now. So he's out of the country. Billy is tied up. I believe he's at work. And so we're going to go solo. I'm going to handle this solo, and we'll kind of make it quick. Interesting week. Again, we'll review the 5 cases that I covered. The first case, one I blogged about last night, is out of Oregon, out of the Eugene Springfield Fire Department. And there's a lot to this one, a lot of legal issues to it. We had a medic who's allegedly stole drugs from both the fire department as well as the hospital during the exchange program, and again, allegedly using the drugs to exchange with women for sexual favors, and also possibly to anesthetize them, sedate them for his own purposes. And again, those are the allegations anyway. But he was arrested and charged with both sex crimes by state courts and also by the DEA for the drug theft. So he's facing a number of different charges. I've got some links to the different stories. The case here involves a lawsuit by one of the alleged victims who's suing the fire department and the hospital, saying that they didn't do enough to manage control over their drug inventory, so that there was some liability there, that they were negligent in managing it, and that they should bear some responsibility for that. So interesting case. Certainly we should be doing a good job of monitoring our prescription meds, controlled substances. And this is not the first time that we've had a firefighter steal and end up getting the organization involved in something well beyond just the mere theft of drugs, but certainly something that we should be watching out for, managing that inventory problem. Okay, and whoops, what happened here? Okay, so that's that first case. Next case here is out of my home state of Rhode Island, and the city of Warwick is going after Warwick firefighters, IAFF Local 2748, claiming that back in 2013 the parties had reached some sort of a negotiated settlement over how much sick time they would be able to recover when they retired, I'm assuming. And now apparently that was memorialized in an MOU, memorandum of understanding, but the city council and the mayor never ratified it. So it was an MOU outside of the collective bargaining agreement. It was never ratified by the mayor. So now you have a new mayor coming in, and this is 9 years ago, saying that because it wasn't duly ratified, that the $385,000 in overpayments that were made back in 2013 are no longer were illegally obtained and must be returned. So a couple of concerns with this. I mean, number one, obviously statute of limitations, because it's been so long. Rhode Island does have a long statute of limitations for sort of the general claims, and whether this would fall in under that general statute of limitations of 10 years. I don't know. We'd have to research that. But that's the first thing. I know many of you had written in about that, asking me about the statute of limitations. So I haven't fully researched whether that 10-year statute would apply to this, or whether a shorter statute would. But that's sort of question number one. Question number two is, can you sue the union for payments that were made to individuals. Usually, in order for the court to have jurisdiction, the individuals have to be parties to it. So if you want money from a certain party, if you overpaid a certain party, firefighter A, let's say, got this overpayment, you can't sue a third party. You can't sue the union. You've got to bring that person into the court's jurisdiction. So not sure what suing the union is actually going to accomplish other than getting the mayor some headlines, I suppose. And maybe that's what it's all about as well. Who knows? So again, there's a couple of things. And then one that that troubles me a little bit on it is that when you have a fully executed agreement, in other words, when both sides to an agreement have fully exercised everything that is required under the agreement, then even though there might not be a properly acknowledged contract in writing, it's been acknowledged by the parties' facts, so that a fully executed agreement where both parties have done what is required is usually sufficient to say, wait a minute, this is a done deal. It's like it would be like if you purchased a car, someone purchased a car, and the dealer didn't sign a certain thing. So obviously the person could back out of the deal, the dealer could back out of the deal, but the transaction goes through, and the person drives the car for several years, and the dealer, turned over title and all of that. Well, the agreement wasn't signed and all, but the parties by their by basically doing what they were required to do under the agreement, they fully demonstrated that it's a fait accompli. And so I think that that's another problem that the city's got to get over. But at any rate, we'll watch it. We'll see where it goes, and hopefully the firefighters will end up getting what they are entitled to, or the city is going to get what they're entitled to as well. And I apologize, I got to move my screen a little bit to access my back button. So let me just kind of move some things around here, and there we go. Okay. So next case here, Bill Macarone and I did a legal update. So, if you're interested in watching that video, kind of brief, I think it's about 20-25 minutes, just on a couple of overtime cases, one out of Honolulu, the other out of Milwaukee. The Honolulu case is the filing of a lawsuit, and the Milwaukee case was a settlement of a lawsuit, pretty substantial settlement as well, $1.6 million. But I mean, Fair Labor Standards cases continue to predominate the fire service legal landscape here. We just keep seeing FLSA cases and big ticket cases, $1.6 million. So again, if you want to take a look at that, Bill does have a class coming up this Wednesday on the executive exemption. This is for fire officers. So if you're wondering about whether certain officers are entitled to overtime, or are they basically exempt executives and aren't entitled to overtime, this class coming up on Wednesday is the one you want to go to. Bill's going to get into details. In fact, even if you've been to our 3-day or the 24-hour FLSA class, FLSA for fire departments class, we can get into some of the details, some of the nuances of that issue in that 24-hour class, but this is going to be about 4 hours just on the executive exemption. And we spend maybe 45 minutes to an hour on it in the 24-hour class. But we're going to spend basically 4 hours just on the executive exemption. And it's important, certainly company officers, lieutenants, captains, there's some concerns, there's some cases that hold that they're exempt executives. There's some cases that say that no, chiefs are. So your battalion chiefs, your deputy chiefs, your shift commanders are, and there's cases that say they're not. So we'll go through all of the nuances in that, but it's a pretty important topic for firefighters. Next case is out of South Carolina, and we've got a fire captain in the Columbia, South Carolina Fire Department, who had posted some comments online that were critical of law enforcement. And I didn't see exactly what was posted, but you can't look at this one case without looking at the history of some of the other cases that have come down out of Columbia. And they had a previous case where a fire captain was terminated over some of the comments that he had made. The first captain that I'm talking about, this one was back in, I believe, 2016 or 2017. But he was a white captain who was complaining about the Black Lives Matter protesters shutting down the interstate highways. And he made some somewhat threatening types of comments that he would run people over and so on. And he was terminated over those types of comments. So now we have an African-American captain who is concerned about one of his relatives. I'm not sure if it was a cousin or a nephew, but was apparently shot at the hands of the Columbia Police Department. And he was voicing his concern about that. And so the posting happened on April 9th, and he was terminated on April 10th. So the very next day he was terminated. And, he's suing to get his job back, alleging that he had a First Amendment right to raise his concerns and express his outrage over what had happened. And so unfortunate situation, but we'll see how that one plays out. And let's see. Next one here is we've got really kind of an unusual case with regard to an Ohio medic. And I was out in Ohio last week. I was at Firehouse Expo. As many of you know, I write for Firehouse Magazine, and was at our conference there at Firehouse Expo in Columbus. And I tried to kind of come into conversation with folks who were at least somewhat aware of this case, and I wasn't able to. But we have a Chester Township medic, fire department medic, who apparently, from what I understand, they responded to a vehicle accident. The person declined treatment. They went back to quarters. The police ended up getting a search warrant to have blood drawn from the suspect. So they called the medics over to the police station and, showed them that they had a court order to get a blood draw. And the medic complied with the order and took the blood sample and went back to quarters. And when the department found out that he had done that, and the medical director found out that he ended up being terminated. And from the department's perspective, what the department apparently, at least according to the lawsuit, what the department said was, well, we didn't fire him. The medical director withdrew his credentials that said that you can't practice as a paramedic under my medical license. Therefore, we don't have a job for you. So once the medical director says you can't practice, you're no longer capable of doing the job for us, so we had to let you go. And the firefighter is saying that violated his due process rights, because how can he have a hearing if the decision was made by a doctor, and the doctor isn't governmental and doesn't have to show that there was just cause for the termination and so on. It's really a sham to give them a hearing when you can't really get to the heart of the issue. And that's in terms of whether or not he did something wrong. Just because the doctor said he did something wrong, won't let him practice under his license, doesn't necessarily mean he did something wrong, and he doesn't have a way to air that grievance. So interesting issue. And, the case is going to continue. The case was filed a while back. And, basically what the court said, the court acknowledged that there's a question about whether or not the doctor's decision is reviewable, but they're not going to allow the fire department to get out of it by having the case dismissed. And so we'll see how that pans out. I would think when the township fire department sought to have the case dismissed, the court basically said, this isn't a situation where it's clear cut and it's going to have to continue. And so we'll see what the next round here is. But it certainly raises an interesting couple a couple of interesting issues. So, and let's see, the last one here we have has to do with the Walmart fire in Plainfield, Indiana. There was a mega warehouse fire, one of these big Walmart distribution center fires, and when those buildings get going, you're talking about hundreds of thousands of dollars worth of damages. And the headlines across the conventional media characterized this as a lawsuit. They said that Walmart had sued, I think it's 34 different fire departments or fire agencies. And my blog post was really just to kind of say, wait a minute, it's not really a lawsuit. It's a civil claim that that Walmart did in fact file, but maybe it'll lead to a lawsuit, maybe it's not, but there's a little bit more. There's an educational opportunity here. So let's kind of get to the facts of the fire. We have a fire. It's folks I know, I've done some training there in Plainfield, Indiana, and from my perspective, they're a good fire department. They are try to keep their people current with the latest tactics. They're certainly not a backwoods fire department, but they have this large facility. They went in initially, and if you can envision these warehouses, they have very, very high rack storage. And I'm not sure exactly how high this one happened to be, but some of them are up 50, 60, 70 feet high. And if you can visualize a fire maybe at the 40-foot level in one of these places, and it's not like a Home Depot store where you have rack storage that's maybe 15 feet, maybe 20 feet at most in a Home Depot. We're talking about 40, 50, 60, 70 feet up. And also because the public is not allowed in these areas, the space between the racks is a lot more narrow. So picture yourself trying to carry a 35-foot ladder in, and then place that 35-foot ladder in an aisle that's a lot closer together than what we typically see in a Home Depot store. And you start to see the problem. And now you've got maybe heavy smoke conditions. You've got the sprinklers are operating. This was a sprinkler building. But you've got a number of obstacles in there. And of course, our air supply is limited, so you can only go so far. You're working hard, and you need to rotate crews, and next crew's got to come in. And very, very challenging type of fire for any fire department. I don't care who it is. Any fire department is going to be challenged by this. But at some point, the sprinklers were turned off so that the firefighters could get in and actually attack the fire. And at that point, the fire took off and got beyond what the fire department and the sprinklers were then able to manage. And by the way, this is not the first time. For those of you who are familiar with this issue, I wrote in Firehouse Magazine about this back in 2009. And same phenomena, exact same situation happened. They shut the sprinklers off. The fire got beyond the capability of the fire department, and there were lawsuits and allegations and so on. And to me, this is not about a negligent firefight. This is more about a negligently designed building. It's not about firefighters screwing up. It's about the people who designed this building and designed this sprinkler system designed something that was not capable of protecting the building. And it wasn't so much on the firefighters. The firefighters were doing the level best that they possibly could. It's really about the design of the way the sprinklers and the rack storage and the overall facility went. So at any rate, that's the world according to Curt anyway. But here's the issue. Okay, what happened that led to the headlines? Walmart did not file a lawsuit. They didn't go to court and say you were negligent. Okay, what they did is they followed the Tort Claims Act in Indiana. Every state and the federal government have a Tort Claims Act. It essentially makes government liable for certain types of things, and it reserves immunity protection in other types of things. And I think this should be one of the areas where the fire departments do have immunity protection, by the way. But be that as it may, in order to hold government liable, your first step has to be to file a civil claim with typically the town clerk, city clerk, fire department agency, whatever it may be. But you've got to follow whatever the Tort Claims Act requires as a predicate to being able to go to court. And normally you have so many days or so many months or so many weeks to do that. And in Indiana, you have 180 days from the date of loss. So in other words, if Walmart was going to go after the fire departments for negligence, they had to file within 180 days of the harm, of the loss. And according to the lawsuit, the fire happened on March 16th or according to the news media, the fire occurred on March 16th, 2020. So basically 6 months that they needed to get it done by roughly September 16th of 2022. And that's what they did. So all they did was they filed a claim with these various fire organizations. Maybe it will turn into a lawsuit. Maybe they, at the end of the day, after they do their due diligence and research this, maybe they'll continue to sue the fire departments. Maybe they won't. Maybe they'll go in a different direction. Maybe they'll go after the engineers, the architects, and so on who designed this. Okay, maybe they'll go after whoever was the cause for the fire. If the fire started in a battery pack, a lithium-ion battery pack that was made by the XYZ company, maybe they'll go after the XYZ company. But the point being is, if they didn't file this claim, they would not be able to go back against the fire department at a later date. So that's really what the headlines were all about. It wasn't that there was a fire. I like it. I like this case because it gives us the opportunity to connect tactics and strategy and the challenges we face with the legal system. And this is sort of that interface between firefighting and the law that really that I get a lot of it just causes me to appreciate both aspects of fire law. Okay. And you've got a copy of the claim. Now, this is the claim that went to the town of Plainfield and the Plainfield fire territory, but each of the entities would have had a similar claim filed against it. Okay, maybe it'll lead to a lawsuit, maybe it won't lead to a lawsuit, but time will tell on that. Okay, and that is going to do it for another edition of Fire Law Roundup. Hopefully next week we're going to have Brad back. I'm pretty sure Brad should be back. I believe he's coming back next Sunday, so I'm not sure. Hopefully he'll have his sea legs under him to help out on Monday. But at any rate, we'll be back to our normal operations pretty soon. Okay, and if you like what you heard, please click like, please click share, and please subscribe. We're trying to get up to 1,000 subscribers. It's a big point for us. If we can get there, it allows us to get better visibility on the YouTube platform. So we really appreciate the support. And it was great seeing, I know a bunch of you commented that you watch us every Monday, and I really appreciate that. But Brad, Billy, and I really appreciate the support where it's a labor of love, truly a labor of love, but it's good to know that folks are watching us. And it was great to see everybody in Columbus last weekend. Okay. And that's going to do it for another edition of Fire Law.